From item number 6 to 15.
May it please the Lordship. Lordship, item number 10 with supplementary.
Adjournment slip circulated, number 8.
22nd April.
Lordship.
His Lordship, item number 13, my lord.
And number 30,
My lord.
you have also circulated the
Yes,
adjournment. All right.
24th April.
My lord. Clearly or George support, they don't care.
24th April.
My lord, I beg to mention item number 15, my lord. In this case, my lord, yesterday we received affidavit in opposition filed by the respondent number 4. So we need to file a reply on that. So, my lord, 3 weeks time may be given me.
You are for the appellant.
I am for the appellant.
As great for, have you informed the other side?
I have already informed other side is all there.
Item 15.
Lordship, I'm therefore responding number 4. We have filed our affidavit yesterday, Lord.
As great for on behalf of the appellant, let this matter come up for consideration on your day.
29th April.
Those outstanding bills of garage.
Yes, my lord.
Okay.
29th April.
29th April.
Obliged.
Much obliged.
From item number 16 to 22.
May I please the Lordship? I beg to mention item number 17.
17,
17, yes, Your Lordship.
that's a PIL.
Yes, Your Lordship. Sir, affidavit in opposition was filed day before yesterday.
As prayed for on behalf of the petitioner, after obtaining the consent of the counsel for the respondent. This matter is adjourned to so and so day.
29 April.
May it please the Lordship, I beg to mention item number 18, 1A.
Adjournment slip circulated, all right.
21st April.
Obliged.
From item number 23 to 27. Adjournment request.
Your Lordship, item number 27 is, we have filed our rejoinder, they have
Item
not
number?
come. 27.
Hmm.
We have filed our rejoinder yesterday, Your Lordship, that has not been taken. Let it come after day after tomorrow, Your Lordship.
Not necessary. The learned counsel for the appellant, that's about village grazing ground.
Yes, Vijay land.
As prayed for on behalf of the appellant, after having taken consent of the respondent. Re-notify also.
23rd March. Any other request?
May I please Lordship. My lord, this is pensionary matters of the casual workers.
What matter?
Pensionary matters of casual workers. We have been denied from pensions in spite of orders of the Honorable Supreme
So
Court.
you have started your mentioning by saying that this relates to pension or daily wage workers.
Casual workers they were. Casual workers.
Workers would not get pension, no?
Casual workers thereafter, well, it is filed in August 20,
Anyway, we'll keep it. You have filed it when?
August 25.
August 25, it shall be listed sometimes in first, second week of March. All right.
Lordship, I'm praying for listing of 2 fresh PIs. The Lordship, I'll hand over a copy of the Supreme Court order, Your Lordship.
Is there a direction of the Supreme?
Lordship. Paragraph number 4, Your Lordship of the order.
Paragraph 4 is, we request the Chief Justice. What is this PIL?
Lordship, we have filed a public interest litigation, Lordship, against the constitutional functionary of the state of Assam, Your Lordship. Thursday, tomorrow, Your Lordship.
When do you want it?
Tomorrow or Friday, Your Lordship.
Then it will be tomorrow.
Tomorrow, Lordship.
There's a request by the Chief Justice of India.
Lordship.
We will fix it tomorrow.
Similar prayer by my senior friend, Your Lordship.
Both there. Tomorrow.
26th. 26th.
Full lगा देंगे.
Keep. Daily list for orders item 1.
Lordship, before my friends begins, Lordship. Lordship is a common judgment. We have filed 2 review petitions. In one, already notice has been issued and the other has also been registered, Lordship. Its number is review petition, Lordship.
Mr.
4 of
Chakravarti,
2026.
Mr. Chakravarti, learned advocate for the respondents. submits that though the efforts have been taken for compliance of the order dated 6/2/2023 passed by this court in WPC number 4045 of 2019, but or the pendency of two review petitions in which notices have been issued to the respondent.
In one of them, notice has been issued.
To the review petitions in which, in one of which notice has been issued to the respondents, the matter is pending. The matter is awaited. The final compliance is awaited. Let this petition, let this case be listed on your date in April mid.
21st April.
Next.
Item 2.
11 awaited. Full respondent has been served. No, full respondent. The service is complete. Let this case come up for consideration under the appropriate heading of admission on your date.
29th April. Item 3.
Awaiting the service of notice on respondent number 11, the matter is adjourned to.
Plus lordship.
6 April. Item 4.
Affidavit right? Yeah, reason? Yes.
My pleasure, Lordship. I received a copy of the opposition yesterday, my lord. So I'd like to take instruction from the client on this.
The counsel for the counsel for the appellant seek some time to respond to the affidavit in opposition. Re-notify.
1/4. Item number 5.
May please, your lordship. Lordship, our steps upon the eye of condemnation has been completed. The private respondent has filed their Wakanda.
That's all right. We are condoning the
Much obliged, ma'am.
delay. Any problem? You look dazed. I'm
40 days.
talking to you. You look
Lordship, my
dazed.
senior is on the way, lordship.
Doesn't matter. Tell your senior that you argued. We are condoning the delay. The appeal to be processed.
Lordship.
Much obliged, ma'am.
Pleasure.
27 April.
Much obliged, ma'am.
Item number 6.
Yes, what is it?
May I please, your lordship. In this case, my lord, I has been filed, my lord, for condemnation of delay, my lord.
Objection has been filed, your lordship.
When?
On 23rd, it is tagged with the record.
Yes, what do you have to say?
Lordship, in paragraph number 5, your lordship, the applicant has stated that
Delay condoned. Appeal to be processed. I can detail it.
29 April.
Contested then.
Item 7.
Notice. Notice to. Notice to respondent.
Delay of 110 days, my lord.
Both modes returnable.
28 April. 20. Item 8.
Yes.
But if we have,
Mr. Nath,
Not we have paid for-
delay on behalf of the state is viewed very seriously. Private parties, we are liberal.
well, in fact, while taking the decision in the process of taking decision, but time.
All right,
taken-
we are
taken.
condoning the delay.
Well, lordship,
Appeal to be processed.
I'm obliged.
Take all the reasons from it.
My lord.
27 April. Supplementary item 28 for orders.
Who appears for respondent number 4?
Also, we have taken registered steps on, let's say, 2/2/2026.
And the office note says, Lordship, that this is not.
What respond number? Okay, awaiting the report regarding service of notice on respond number 4. The matter is adjourned to.
All right.
2nd April. Daily list for admission item 9.
Lordship, I have received instruction from Ministry of Home Affairs.
What is the instruction?
Lordship, they said that the earlier petition was dismissed on, not on merit, Lordship.
That's a wrong statement. That's an incorrect,
Lordship, please to see page,
you put it on record, we don't accept this. We'll have to reject this.
Lordship,
Look at this, Mr. Kel.
Lordship,
The court decided that the respondent deserves to be paid. Correct?
Lordship,
Now, for whatever reason, the swapping was only with respect to the liability of the department. Now we take the Union of India as a sole, as one entity.
correct,
They are not concerned whether you pay. When you make payments, the other side would not look for the color of the skin of the hand which doles out the payment. So therefore, on principle, it is correct. We'll have to dismiss it, lock, stock and barrel. Put it on record, we dismiss this reason.
Lordship,
You go to Supreme Court,
Lordship,
because this matter appears to be decided. Because you would require to go to Supreme Court, therefore put it on record, we will dismiss it by reason we are telling you beforehand what we will do.
Lordship,
Do it by tomorrow,
Lordship,
so that you get opportunity to challenge our order, we will say.
Lordship,
Because we don't make any distinction, who is to pay.
Lordship. I know.
Correct. So do you want it to be, do you want your ground to be put on record, or do we dismiss it just like that?
Lordship, ground may be taken into consideration.
We will take it, you don't want to put it on record.
Lordship, this may be put into record, and this Lordship, paragraph 10 of
No,
the
this we can't take on record. This is a communication from a client to you.
Lordship,
It's a privileged communication. Put it on record,
Lordship,
and please don't mistake this. Don't commit this mistake, Mr. Kyan.
no, Lordship will do.
Just a minute. Many a times, the sender of this communication would question that this was only for you to vet. Why did you put it? Why did you
Oh, Lordship,
ask the court to take it on record just like that?
Lordship, Lordship may record as my statement.
But you're again not understanding. This statement will not help you in the top court. You have to put it on record.
Lordship, my submission.
Or if you are ready to pay, we dismiss it otherwise. You are not followed. We are covering your interest.
Lordship,
We are covering your interest so that, the department doesn't say, and we also will say that, no, we don't consider it. Anyway.
No.
He says, so why do we keep it? Very well, we take it on record, but in Supreme Court, you will be questioned. Why? You did not put it on record.
wait.
We have heard Mr. S.C.K.L., learned advocate for the appellant / Union of India in the Home Ministry. And Mr. P.D. Nair, learned advocate for the respondent number
1 to 12, my lord.
1 to 12. The state of Mizoram is represented by M.S.P. Bhattacharya, Additional Advocate General. By the judgment dated 15/11/2023, a learned single judge in his court in WPC number so and so directed the appellants to pay to the respondent number so and so the rental for their lands which were occupied by the security forces for a long period of time, and also awarded interest at the rate of 6% per annum till the final realization of the compensation amount. The aforementioned judgment was questioned by Union of India, but in the Defense Department by writ appeal number 6 of 2024. the challenge could not be sustained. And a division bench of this court by judgment dated 15/5/2024 a clarification was made that the liability of making payment to the respondents would fall on the Home Department of Union of India. Mr. Cal, learned counsel for the Appellant Union of India submits that before making that clarification, the Home Department ought to have been heard. This submission of Mr. Cal did not find favor with us on an earlier occasion when the matter was heard, on the ground that it matters not as to which department of Union of India would make payments of compensation for, would make payments of the rental of the would make payment for the compensation, would make payment towards compensation to the respondent, as Union of India is one entity. Stop. Even otherwise on merits, come on, the division bench in writ appeal number 6 of 2024 made it very clear that there was no tenable ground of challenge against the learned single judge holding that the private respondents are to be compensated for the use of their land for a long time. In that view of the matter, any appeal preferred by a different department of the government would not be maintainable on the sole ground that the responsibility to pay does not lie with the Home Department. This is a matter of internal arrangement inter-C departments of the Union of India, which does not in any manner dilute the rights accrued to the private respondents. Today, Mr. Cal has placed on record, Mr. Cal has shown to this court a communication made to him by the Under Secretary to the Government of India in the Health Department, dated 3/2/2026. Stating that since the appellate order in question did not delve into the merits of the case, therefore, the present appeal is maintainable. We have taken the aforenoted communication filed across the board on record. The reasoning does not convince this court. The reasoning does not convince this court so far as the maintainability of this appeal. The appellant would be well advised to challenge the division bench order before the appropriate forum. Entertaining this appeal would be hearing a matter which has already been decided by a bench of co-equal strength. Finding this appeal to be not maintainable with dismissal.
May I just add?
We dismiss the same. Leave, dismiss the same with the liberty reserved to the appellant to challenge the aforenoted appellate order in the appropriate form.
Much.
My lord, the submission
Yes,
was,
Mr. Nair.
my lord, the submission was, my lord, that the Ministry of Home was not heard, my lord, in the prior writ appeal, my lord. My lord, that is from the reading of the writ appeal's order. The appellant Ministry of Defense was represented by Mr. Medhi, and the CGC was.
We say so, that is the reasoning given, no?
My.
Well, that is, we have said that
Ma'am.
two departments intercede, we don't know on merits, it has been decided.
But Ministry of Home was heard.
Now you, before you get paid, you will have to fight another litigation before another forum. Let's see, we can't help it. Come on.
Deeply obliged, my lord.
Yes.
Deep.
Item 11.
लोग उस समय देखा था क्या थे? Last time,
Lordship.
we are forgetting, you just have to remind us, we had examined the provisions of SSD service rule.
The person was discharged from service on the ground of unsuitability under Rule 26,
Please, we have crossed that stage.
Lordship.
Now, which provision did we examine on the last occasion? I mean, we forgot since I did not make an introductory, order. Now,
Rule-
let us see those rules.
Rule 26 read with Section 10, Lordship.
Give us those rules. SSB, what is the name of those rules?
Sasastra Simabal Rule, 2009.
Which section?
Rule 26 read with Section 10,
Rule 26
Lordship.
of the rules.
Rules.
2009. Rule 26. Termination of service of controlled person to the grounds of unsuitability. लिख it. एक सेकंड हमको ये पहले ये तो एक 90 and the 21. 21 21 and 26. ठीक है ना? वो तो ग्राउंड चला गया तब मेरे पास चल रहा था civil offenses not liable by no 75 है क्या? Not necessarily, not necessarily. है वो तो that is always है वो procedure में है absence without leave तो it punishment to conviction that sports combination of ऐसे ऐसे हुआ है How has he dealt with it? Show us the termination order.
Lordship, page 53.
Convicted under 226. Whereas the big check of that. Termination. Rule बताया है तो numbering को तो satisfy करता है. Whereas just a minute, because this thing has been convicted under 226. ये तो termination. Convicted, whereas it considered. Let the conviction is rendering further. ये क्या है? ये इसके is not fit to be retained. You must choose your words correctly. You say that he is convicted under Rule 21. Now, conviction requires the matter to be placed before the force court. Now, you have not done that. But seen in the context of the notice which you've given, it appears that you are taking an action under Rule 18 read with 26. Correct?
Lordship.
So, but who will advise you to do this? Yes.
Rule 26 has been properly followed. The mandate of Rule 26.
Difficulty is that the
Lordship.
but you say that he has been convicted.
But the
Where is conviction?
discharge order is clear, Lordship.
Which order?
This discharge order. page 53.
Perhaps you have not understood where we are stuck up and where you lost the case before the single judge. You say it is very clear. It is very clear. If you say that it is very clear, then we sustain the order. This is termination on grounds of unsuitability,
Lordship.
where there is no reason, there is no compulsion of summoning the force courts for summary of whichever trial.
Lordship.
But look at the word that you've used. He has been convicted under Rule 26. There is no conviction. Conviction under Rule 26 is termination. He has been held to be liable to be terminated. That you could have said.
Lordship.
So therefore, he is jumping on his seat. Yes.
My lord. Page
You are
53.
unsuitable, sir. Every time you take leave.
No, my lord, whatever I have done wrong, my lord, I have undergone punishment.
No. Those are packed. So this is no stigma. You have not been able to conduct yourself as an army man. You go to leave, you report back after 4 months, 5
My
months.
lord, because of my
Just
lord,
a minute, many a times he was sent on pack drill, different punishments. These are no punishments. So ultimately it was found that you are incorrigibly indisciplined. Let you go out of service. And that they have done only because they have used the word conviction under Rule 26.
my lord.
We don't expect them to be, you don't expect them to be as proficient in legal language as you.
They said, my lord, conviction, my lord, nowhere it is conviction.
The single judge has only gone on that.
Because of the conviction, my lord, what
Where
is
is the discussion that with respect to, if it is compared, if the wording at page 53 is compared with the notice which was in contemplation of the authority, it was termination for being unsuitable for the job. Nothing is required. Your appeal has been dismissed. I think the court immediately caught on to the word conviction.
No.
But conviction, but they make it very clear by saying that it is under Rule 26. Rule 26 does not talk of any summoning of force courts. I think I'm very clear on that.
my lord, before the honorable,
See, the single judge did not find that the allegation against you was incorrect. No. The single judge only found that if you have been convicted, then there is a different procedure. There had to be a force court. Now you have not been convicted. You have only been terminated for unsuitability, which impression was gained by the commandant as you people normally say. And then your past records were taken into account, and therefore they asked you to resign first. Since you did not resign, you were found to be unsuitable. You were shown the door. Bolia, we have not allowed you to speak. We have only spoken. Now, this is what is passing on in our minds. If you want to controvert that, please do that.
my lord, before the honorable single judge, my lord, they have filed a rejoinder affidavit, my lord. They said, my lord, they have contemplated to take action under Rule 18 and 21. That is part of their affidavit at page 113. my.
So that's right. That rejoinder is good. Now come to 18.
But
18 of the rules. That's
yeah,
what I
my
said.
lord, you
Come to Rule 18 of the rules of 2009.
my lord. These are the officers who can take action.
Look, we are giving you all this opportunity because the judgment is going to be reversed. And you will be at the receiving end. Therefore, you argue whichever point you have in your sleeve. Please.
And moreover, my lord, I have a basic argument is that before the honorable single judge is that, my lord, they said conviction, my lord. Because of my termination
All this while we have been saying this, no.
and whatever punishment I have undergone, my lord, for my matrimonial dispute, my lord, here,
That we don't appreciate. That we do not appreciate in your favor.
or lordship,
MS Sharma was not very choosy with her words. Not with her, with the client's word. No. That is the notice. Notice is the first point of, contact with you so far as your unsuitability is concerned. So we derive the intention, it was in contemplation. The animus decidendi was this. This judgment has to go.
My lord, what I pray before this stage, my lord, since your lordship has pointed out, my lord, Shoka's notice has not been taken into account while passing the impine order. So my prayer at this stage, my lord, let the matter
Suppose.
be remanded back to the honorable single judge for
That's not required. For remand, we find this to be absolutely incorrect exposition of law. Why do we remand it? We said it, say.
my lord. What about, my lord, the impine, the language, my lord, in the next? That, my lord, cannot be.
No. That remand, it doesn't fall in the category of cases where remand would be
My lord.
justified.
But impine order, my lord, they said for conviction, my lord, which led to, my lord, and my appeal was also rejected because of a statutory period of 90 days. I filed beyond that.
No, everywhere you come late, except High Court.
I could also, my lord, I went to tribunal Chandigarh, my lord, there some lawyer advised me, then High Court, then this Gauhati one.
Mr. Porbhoya, you'll have to accept our judgment. No. We don't find it to be a case where the judgment of the, or where the judgment and decision of your employer is to be faulted. Unfortunate.
And secondly, my lord, the impine order, my lord, it primarily reveals, my lord, conviction. Because of the conviction, my job was terminated.
Let us-
Where is the conviction?
Let us not repeat.
Lost.
When they say that it is under Rule 18 and 21, so it means that the expression conviction has wrongly been. That has been specified. Suppose a judge passes an order under Article 226 but mistakenly writes 227. Can the other side come and say that no appeal? Can the person concerned, if he has an order in his favor, come and say that no appeal will lie because this is under 227? I'm putting you an example. I'm giving you an example. Or even that, suppose a judgment is passed in a petition filed under Article 226. A judgment is passed. Now that is sought to be challenged. The appellate court thinks that, well, though the petition has been filed, though the petition was filed under 227, but the nature of the order passed by the single judge is akin to an order passed under Article 226. Would appeal be maintainable or not? Substance is important, not the rubric.
My lord. Apart from this, my lord, Rule 26 is taken into account, my lord. There is some steps is there, my lord, procedure. That has not been also
No,
followed.
that has been
That
followed.
has
See, for
No, my
conviction-
lord, they have to call me, my lord. Either you tender resignation
Yes.
or you go. Where is the document, my lord?
They did. You have not replied.
No, my lord, they could not have produced before the honorable single judge also.
Last week. But you have not denied that. Where have you said that? No, I was not asked to resign.
So the reply.
No. You have a bad case, right? We gave you all the time. And allowed it. The appeal stand is allowed. The judgment of the learned single judge is reversed. The termination of the respondent is upheld.
Much obliged.
Item 12,
Obliged.
Wait, please, my lord. My lord, two judgments dated 11/2/2021 and against which a review was preferred and the review was rejected on 26/09/2023 is under challenge.
Just a minute. That is also one of the. Yes, sir. Yes.
Yes, my lord. My lord, the matter pertains to appointment of an Anganwari worker, my lord.
Just a minute. Give us a minute.
Yes, my lord.
एक है एक है परुवा पजिपर, एक है परुवा पजिपर अब. Up is east. Okay. Knows that difficulty. We would not be in a position to distinguish that reasoning is correct. Now, initially, these are two contiguous Anganwari centers.
The name has created all the confusion.
No, not name.
Yes.
Name had created confusion in the beginning when you were appointed.
Yes.
So
No,
that is-
I was not there. I was in the review petition. Yes, when I was appointed. Yes, yes.
you were appointed.
Right.
Respondent number one preferred a writ petition. The writ petition was allowed. You were removed.
Exactly.
He was appointed.
Yes.
And thereafter you went in review. That also was dismissed.
Yes.
But
Yes.
see, it is the names are slightly
Yes.
different.
So-
एक है परुवा पजिपर,
Exactly.
Up is east.
Exactly. My lords, kindly hear me out, my lords. My lords, here, my lords, the name has created all the trouble, my lords. The confusion has arisen because of the name, but we may not rely on the name at all, my lords.
Tell me one
Because
thing.
the
Tell me
name.
one thing.
Yes,
Before that,
yes,
before I ask you to
Yes.
tell us on facts,
Yes.
something more than what we need to know.
Yes, my lord.
Now, this advertisement was issued in 2019,
Right, my lord.
Hmm?
Right.
and your appointment was made first when?
My appointment was made on, my lords, 28/02/2020, my lord.
2020.
20, my lords.
And
28
you
February.
were made to exit that post,
Yes.
when?
By virtue of the first judgment, my lords, 11/2/2021.
That's all right. So when was Sangeeta Haloi Parua appointed and others?
Subsequent to the first judgment.
14/6/2021.
14
Since then I have been working now.
14/6/2021. Since then she's working.
Yes. Now, my lords, kindly hear me out, my lords. My lords, the names, my lords, Parua Pajipur and Parua Pajipur Poop, my lord. The names itself are inconsequential, my lord, and we should not rely on the names, my lord. Names have created all the confusion, my lord. I'll very briefly explain, my lord, what had happened, my lord. My lord, these two Anganwari centers, my lord, are adjacent to each other, my lord. And the advertisement was issued for Parua Pajipur, which is center number 23, my lord. There are two center numbers, 23 and 217. Now, few things are admitted here, my lord. That the respondent number 1 is a resident of center number 217, and that the appellant, my lords, is a resident of center number 23. It's an admitted fact, my lords. Both the parties admit that we are members of such and such center numbers. Now, lordship has to just see, my lords, where the vacancy had arisen. That was never seen by the honorable judge, honorable single judge. What had happened, my lords? In center number 23, there was this existing Anganwari worker, my lords, Onima Bejborwa, my lords. And upon her death, my lords, the post was advertised again, my lords. It was not a newly created post, my lords. It was a vacant post, and various other vacant posts in the
Why did
district.
you not argue this in review?
I argued it, my lords. The lordship had issued notice in the review petition, and thereafter, during the
In
judgment.
review, you were giving some other document. You should have just brought the advertisement.
Yes.
And the fact, but these facts were known to you from before.
No,
And in fact, the
we
advertisement was-
argued that. We argued that in the first, my lord would see in the first judgment, my lord, that was precisely argued that the vacancy arose in 23. That somehow because of the name, my lord, it was not given much importance, my lord. Now, my lords, in the center number 217, my lord, it's clear, my lord, from the
Let's see the advertisement.
yes, my lords. Advertisement, my lords, is at page number 65.
These Anganwari engagements, these are no substantive service. I mean, there are high courts where dispute with respect to Anganwari workers is not entertained in writ petition.
As a
These are no
consequence,
substantive appointment.
but
These
as
are
a consequence,
constitutional post or something.
a person
These
belonging
are
to.
just engagements
Yes.
for 1,500 rupees, 2,000 rupees.
Exactly,
I want litigation unnecessary.
exactly.
Just to appropriate the Poshahar money.
Exactly.
Nothing more.
But my lord, there is a
I've
person
seen
belonging
much
to
litigation here
a
for the
person,
last several years,
a person belonging to a different center has been appointed to an Anganwari, which would harm the project, my lord.
but the
There's a
authorities.
reason why, my lord, the Anganwari
Let us see
members.
the advertisement.
Yes, yes. Page 65, my lord. This is the type copy. Applications are invited from interested female candidates for rendering voluntary services against vacant posts of Anganwari helper, so and so Anganwari centers under Nalbari ICDS project, Nalbari Social Welfare Department of the Government of
Where
Assam.
is the mention?
Terms and condition, my lord. Number 2, the applicant should be a local resident of the concerned center area.
Where is the number?
Yes,
Where is the name?
Center number and name, my lord. This is the advertisement appended by my learned friend in the writ petition, my lord. It was appended by him as a petitioner. So, well, admittedly, my lord, the center numbers are not there, my lord. Center numbers are not there. My lord would kindly see.
Have you made a statement that there was only vacancy in center number 23 and not 270?
Yes,
Have you
I'll
made that
directly,
statement?
I'll directly come to that, my lord. I'll directly come to that. My lord would kindly come to. Directly come to page 20, page 157, my lord. Page 157. Certified that Srimoti Mamuni Kolta Bejbora, wife of so-and-so, 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 is the resident of my area. I know her very well. I wish her success in future life. There are 2 Anganwari centers in Khata Pajipar. The village surveyed into 2 parts by establishing an Anganwari center in the year 2009-10. There are Pajipar Anganwari Center 217 and Parua Pajipur Anganwari Center number 23.
Who is disputing it? You yourself said that.
No one is disputing.
No one is disputing.
Yes, now.
We don't want this.
Yes, now my lord,
We want
now my lord, directly come to the sir.
position in
Yes.
particular Anganwari center.
Page 159, my lord. Page 159. My lord has it, my lord?
Yes.
Page 159. My lords may also produce the vernacular. My learned, this vernacular is also available, my lord.
This is Pajipar.
Pajipar, my lord would see the code.
East part.
My lord would see the code 215. 217, I'm so sorry, my lord. 217, my lord has seen it.
So the respondent.
217, and my lord would see Anganwari worker, Srimoti Podumi Bejborwa. There is already an.
We don't know.
No, there's already an incumbent Anganwari worker who's already there working.
Just a minute.
Yes, my lord. I'm so sorry, my lord. 217, my lord. There's already an existing Anganwari worker. And
Manda, tell me one thing.
yes.
Now, this certificate does not tell us anything.
Yes.
Padmi Bezbarua has not questioned, no?
No. Yes, no. Podumi Bolwa is the incumbent who's already working in 217. And no, Mamoni is Sangita Hello. My lord would come to page 161. Page 161.
We are not able to get you.
No, my lord, give me some. I'll try my best to explain. 1 minute. My lord, may come to page 161 for a moment. Kindly, my lord. No, my apologies, my lord. I'm not
I
being trying.
understand that you are facing a rough weather here because we don't want to interfere in this Anganwadi worker.
Yes,
thing.
161.
Unless it is very,
This-
very clear to us.
Illegal, patently illegal. 161. My lord has seen Srimoti Sangita Haloi Bejborwa. So she's a member of 217. Anganwari Center number 217. Sangita Haloi Bejborwa, who's the respondent number 1.
We're trying our patience.
Yes.
For the reason we are not concerned with that. There are few.
The precise question I'll answer.
Mr. Mahanta,
Yes.
there are few established facts,
My lord.
no disputes about it.
Yes.
Vacancy arose in one of the centers.
Yes.
We do not know, looking at the advertisement, which center was this, 23 or 217?
Yes. Exactly.
You belong to 223.
Admittedly.
No disputes.
No dispute. 217.
Koloi belongs to 217.
217.
Right.
Right.
So in the absence of any statement with respect to the vacancy position arising there,
Yes.
you're only trying to rely on a subsisting incumbent lady
Yes.
as so and so to say that it was not for 217, It was only for 23.
23.
And that's your only reason.
That's not the only one. There's another, my lord. My lord, the
Who appears for the
person,
department.
the person who was.
Just a minute, who appears for the department? Now, make a clear statement today
Yes, yes.
that this vacancy was for Anganwari Center number 23 or 217.
My lord, page 30, there is a clear mention, my lord, page 30. Thus, learned advocate, my lord, page third paragraph, Mr. Dina, learned advocate, council for a statement submitted as per official records, which he has
No
brought
center
today.
number.
The advertisement for filling up the vacant post of Anganwari worker is in relation to
Now,
Parwa
this is a statement. So here he is questioning this.
Who-
He says, just a minute,
Anganwari Center.
you're waiting for the respondent now.
Yes, one.
After here, we will,
My lord.
before disturbing your appointment, we will call upon you. Now, let
Yes,
Mr.
yes.
Mahanta
Yes,
make a first.
Yes,
You
yes.
sit down.
yes,
Please sit
yes,
down.
yes, yes.
Now,
My lord,
just a
I'm
minute,
so sorry. I'm
you have said that. Just tell us, make a clear statement that this vacancy may have arisen in 23, but your advertisement was for center number 217. File an affidavit. We'll permanently close this. Otherwise,
Yes.
Mr. Mahanta will keep on agitating.
Because my lord, the incumbent Anganwari worker who was in 23 had expired, and it will appear from
Tell
the.
me one thing.
And yes.
Where is she working? Where is MS Following working?
Hold on, on record.
Mr. Canam,
My lord, as per their advertisement, there is no number, my lord.
where are you working at?
My lord, Parwara, Pajipar, Pub Anganwari Center.
Everyone knows the number, my lord.
There is no number, my lord. As per their statement, there is no number.
Everyone knows the number of their own Anganwari center, my lord.
Mr. Barua.
Yeah.
You don't look dazed. You make a statement that the respondent is working as an Anganwari in center number 217. That will be the end of it.
Exactly. Yes, let them make that statement.
Make a statement.
Yes, but at the moment, I'm little handicapped for the moment because
We are asking you to do it next week.
yes, our name hasn't been reflected. So without the file, I will make, I will,
Don't get into all this.
I will file the. I will,
Do we look for all this?
no,
Whose name is there, who is not there? You
So,
take instructions
we
from
have
the
to-
government council.
yes, we have to miss the.
The learned
file.
advocate general is sitting behind you. He will not say that, why have you taken up the brief which has not been allotted to you? He will not say that. You're here to assist the court.
Only today we came to know that.
How so
we had a
before we
public-
are not
next
asking
week,
you to make
Next
decisions
week, we'll make that.
And this Anganwari center, the unnecessary confusion because it has not been clarified. Mr. Nath made a statement before the review court or maybe before the learned single judge. And there was no supporting paper. That's the only difficulty.
Yes, the number, my lord. That will give it a quietus, my lord. We settle the issue, clinch the issue, my lord.
It has already been given a coitus. You want to stroke it.
Yes,
You
yes.
do not want a decent burial. You want all these discussions. That is the whole problem.
217 or 23. That would solve it.
We have heard Mr. P. Mohanta, learned advocate for the appellant, Mr. N. Sharma for respondent number 1, and Mr. S. Barua for respondents number 2, 3, 5, and 6. Correct? Party position is correct?
Yes.
For respondents number 2, 3, 5, and 6. This case revolves around a dispute over the appointment of an Anganwari worker under the ICDS project in Nalbari, Assam. Pursuant to an advertisement issued in 2019 for filling up one position of an Anganwari worker, the appellant had applied on the impression that this vacancy was for Paruva Pazipar Anganwari Center number 23 and was selected as well. However, such selection of the appellant was questioned by respondent number 1 in a writ petition by WPC number so and so. Stop. It was contended by the respondent / writ petitioner. Respondent number 1 / writ petitioner that the appellant was a resident of Anganwari, a resident of Paruva Pazipar, bracket center number 23, whereas the vacancy was for Paruva Pazipar 2, bracket P is within a bigger bracket. Bracket, then again, another bracket, center number 217. The respondent number 1, as writ petitioner claimed that she resided in the territorial jurisdiction of center number 2217, and therefore she had a better claim than the appellant. The learned single judge allowed the writ petition, holding that the rejection of the candidature of respondent number 1 was unjust. The aforementioned decision was arrived at on the basis of some certificates having been issued by the authorities and a sketch map demonstrating that respondent number 1 resided in the area which would be covered by center number 217. A review petition was filed by the appellant with some new documents to demonstrate that the vacancy which had arisen was tied to center number 23. We are not making any wrong statement in the order.
23.
Please listen to the order carefully.
Yes.
So we are choosing our words carefully.
Yes.
So that you don't come up again.
Yes.
What did I say, Robin? I didn't hear. क्या बोल रहे हो? फिर से बोलो, फिर से बोलो. The vacancy which had arisen and for which the advertisement was issued was tied to center number 23 and not center number 217. And therefore, the respondent number 1, being a resident of center number 217, was not eligible on the ground of her residency.
Yes.
Correct?
Outside the center area, Mills.
Residency. So
Precisely, Mills.
on the ground of a residence. However, the review petition was dismissed on the ground that the appellant only attempted at a rehearing of the case which was not permissible in the review jurisdiction. Mr. Mahanta has drawn the attention of this court to the advertisement for filling up the vacancy, which on a plain reading does not specifically indicate whether the vacancy position was tied to center number 23 or 217. However, from the records which reveal the statement of one of the learned advocates for the state, had made a statement that the vacancy position was with respect to center number 217.
He didn't
That is what
specify this. He didn't specify the
Mr. D
center, only the name.
Consenso,
Only the name. He didn't specify the number, only the name.
stated that the vacancy position was for center number Parwa Bazar,
Parwa Pajipur 2.
Parwa Pazipur Pum.
He did not mention the number. That's why the problem arose.
The only contention of Mr. Mahanta today is that if the center number would have been specifically clarified, this confusion would not have arisen. For the reason that a Anganwari worker in center number 23 had died, which had resulted in the vacancy.
Yes.
Whereas the Anganwari center, whereas the Anganwari worker in 270, in center number 217 had already been working.
Yes.
So by this analogy, Mr. Mahanta has argued that in the absence of any specific stipulation in the advertisement with respect to the particular Anganwadi center, in all its probability, the vacancy position was tied to center number 23, where within whose territorial jurisdiction the appellant resided, and therefore she has a better claim. We have asked Mr. Barua, Learned Counsel, correspondence number 2, 3, 5, and 6, to clearly state on affidavit whether the vacancy position with respect to which the advertisement in question was issued in 2019 was with respect to Anganwari Center number 217, where, no, 17, whether is all right, on 2017, where respondent number 1 is presently working as an Anganwari worker since 2021. Re-notify on, make a statement. Let us put a decent quietus to this dispute. Mr. Mahanta, do we say that this matter ought not to be argued in such depth? This is just an Anganwari work. Anyway, after 2 weeks.
Very grateful, man.
23rd March. Item 14.
What is his name? Mr. Sharma, you be careful. Now that he has forced us to, get into the tickets of the facts, because there where you have been appointed, their Anganwadi worker already had been working.
That is not my.
And so therefore let that statement come not from you, but from Mr. Barua. Yes.
Item 14.
Yeah.
I'm holding.
Where is Mr. Nayak?
Lordship, I'm appearing on behalf of Mr. P. Nayak. Lordship, as per our instructions, the construction is nearing completion. However, Lordship, in addition to that, we're awaiting some recent development in response to that.
Development.
Lordship, there is
They want a replacement of that wooden culvert which was demolished by you
Lordship.
for constructing a road or something. They want a culvert to be made because in the absence of that culvert, there is no passage of passes to rainwater leading to artificial flooding during rain. That's only.
Lordship, it is nearing completion as per instructions.
What is nearing completion? This is for the benefit of the entire area. Now, the construction is at the same place where a wooden culvert was.
Lordship, yes, it was dismantled,
Where have you said
the
so?
wooden culvert, but the RCC culvert is nearing completion, Lordship. And in addition to that, in response to a previous public petition, Lordship.
No. Is that some the required instructions for filing? No culvert. You have to seek instructions in the matter and find out the feasibility of construction of ours. You have made culvert at the same place.
Yes, Lordship.
Are you
There's an RCC box culvert.
Where is that statement? Let's see.
I have the instruction with me.
Oh, where is the affidavit? Let's see this. Mr. Biswas.
Yes.
Please have a look at this communication. I think your job is done. Let us not drag it any further. She has underlined the relevant portion. You can see that.
Yes, ma'am.
So we close this.
Yes, yes.
We will keep it on record. Madam,
Lordship, yes, Lordship.
We have heard Mr. Biswas. Mr. Biswas, learned advocate for the petitioner. And
A. Bhattakur, Lordship,
so and so. For respond number,
1, 2, and 3.
this PIL had been filed by the residents of Bashbera village in the district of Sonitpur, seeking an intervention from this court for the construction of a culvert on the Kolakuchi Garjuli PWD road. A wooden culvert had been existing at that location, which was dismantled for construction of a road under the Assam Mala scheme. The contention on behalf of the state is that in place of the existing wooden culvert, a new RCC box culvert of span of 6 meters has been sanctioned. And today, the work is almost at the almost on completion. Work is almost on completion. With this statement made on behalf of the respondent, we do not consider it necessary to continue with this petition any further, as the grievance of the petitioners have already been redressed. We have also taken on record the communication made by Chief Engineer PWD Roads, Assam, to the Learned Standing Council PWRD Assam, intimating that the RCC culvert at the place where the wooden culvert had existed has almost been completed and shall become functional within a short span of time. We have taken on record, we take it on record. The petition stands closed.
Highly obliged.
Item 16.
Maybe Lordship, I am praying for time being, my lord, Mr.
Why did you not mention it in the beginning?
Time being, my lord. Senior advocate.
Time being, we don't know when we will get happen. Time being is, it goes. Okay, let this matter come up for consideration next week. Mr. Mahanta, next week.
Next, no problem. Yesterday we have filed also.
It's rule 46.
46 is not applicable in this case. That is the case, madam. Only for.
Was that the first meeting?
Yes.
Do you say that no quorum is required?
Quorum is required. In adjourned meeting, quorum is not required.
That's what I'm asking.
That is their case.
That's their
case. And in fact, that was the point they have not argued before Ranat Singh Ujjal.
All right. Who leads you in this matter?
Mr. Senior Advocate M.K. Chaudhary, my lord.
Mr.
M.K. Chaudhary, my lord.
M.K. Chaudhary. For the unavailability of Mr. M.K. Chaudhary, learned senior advocate, who is to address this court on behalf of the respondents presently, the matter is
Appellant.
9th March, 9-3.
Obligation.
Item 19.
Mr. Mahanta and senior advocate, however, is present. ऊपर में नहीं छोड़ना ऐसे ही ऊपर में नाम
May I please your lordship? Lordship, my senior is court number 3. Kindly pass over, madam.
Yesterday only we were reminding ourselves that in many of the other jurisdictions, the Chief Justice would always take offense that instead of court number 1, lawyers have been in other courts. Only because we don't take exception to it, you don't make it a habit. I don't think I'm asking for much if I say that some priority is to be given to matters in court number 1. All courts are equal. You can't discharge your responsibility only in one court. But then if a matter is here, you must get ready. Then we adjourn it for a longer date.
Yes.
There is a limit to accommodation, no? A prayer for adjournment has been made. A prayer for Passover has been made. Consider seeing the board today, it is not possible to accede to such a request. Let this matter come up for consideration on next to next week. Yes, sir.
1st April.
Their opinion. We'll get up for a while. We come back in 15 minutes. Who appears in this matter? 20, 21, 2? Mr. Nath, you are appearing?
Yeah, I'm.
Where is Mr. Das?
Lordship, in items number 21 and 22, Lordship, we have been recently engaged. My senior has been recently engaged as amicus curiae,
Who
Lordship.
has been engaged? Mr. Das?
Mr. Das, Lordship.
Where is Mr. Das?
He's on legs in another court, Lordship.
What other codes? I mean, it gives me, it is very heartening to note that all other codes are functioning.
Lordship, for weeks' time, maybe
Learned advocate for the appellant and learned advocate for the appellant and
All the petitions, my lord, all the petitions, my lord.
no, there is one appeal.
Lord, appeal I filed, my lord, with due respect, my lord, I filed, my lord. I filed the appeal against the learned single judge, my lord.
Mr. Henkandar Singh, you are very tentative in your submissions.
Assuring.
Don't be so tentative. Just seek time. Don't take all these grounds. We don't bother whether it is listed for orders. We decide applications even in orders if the parties are here.
My lord, that is there, my lord. That is there, my lord.
We
I'm
will
not,
decide
I'm
it
not,
at the stage of
I'm
admission.
not. I'm with your
No,
lordship, my lord.
so-
I'm with your lordship, my lord.
So being very rigid, we could keep it for hearing.
What, my
Doesn't
lord?
matter if
What?
that satisfies.
My lord,
But we don't want to give this impression to the advocates at large that unless it is listed for hearing, we will not hear it.
my lord, that is correct, my lord. That is, I'm not on date, my lord. I'm not on date, my lord.
Well,
What, my lord?
Give us a date.
Yes,
Give us a date when it will be comfortable for you to come from Manipur.
my lord.
You're from Manipur.
Yes.
When do you want to come from Manipur to
Come on,
Advocacy?
lordship.
Give us the dates. See your calendar. Don't apply your mind to other things.
April, March, April, no?
You want to go in April, May, your
No.
choice.
Lord, I just want, with the permission, my lord, let me point out the order passed by the.
15 minutes, we come back by 15 minutes, then tell us the date. Yes,
My lord, may I please, my lord? My lord,
give us the date.
my lord, after checking the records, my lord, I'm extremely sorry, my lord. Serial number 30, my lord. If you also kindly have a look, my lord, serial number 30, my lord. That respondent number 5, 7, Natasha, 5, 7, 9 and 13, my lord. Lord, they have not yet turned up before this court. Because they have
Notices
not,
have
no notice was served as yet. And then serial number, my lord, 29. Respondent number 3, MPSC is not yet turned up before this court. Notice has to go.
Notices gone to the respondents or not in all these matters.
No, my lord. This is the first time. This is the first time, my lord.
Item number 29, 30 and 31 layout. Therefore, we say no, without checking up the records, you make statement.
My lord, I'm sorry for that, my lord. I'm sorry for that.
Item number 29. Who not appearing? Where is the order of the Supreme Court transferring judgment? Where is that? Where is the order of the Supreme Court transferring these
That
matters
is-
from?
That is, can you
Show it to us.
Yes, this is not one. Yes, my lord. Sorry. Kailangan transfer. Ano pa yung ba?
Yes. All the three items will go. The aforementioned writ appeal and the writ petitions have been listed before this court, or the same having been transferred to this court by the order of the Honorable Supreme Court dated 28th of October 2025. Let fresh notices to the respondent in all such petitions be issued, for which necessary requisites shall be filed by the appellant and petitioners within a period of 3 weeks.
Yes, my lord.
Within a period of 3 weeks, both modes returnable may end.
Item number 29, 30, 31, my lord. I'm representing R12123.
So, unko minus R1.
R1, R3 in item number 29, 30.
Give your appearance slip. Utna minus cut it.
Grant all rights, my.
All right.
25th May. Item 2222.
My apologies, my lord. My lord.
Yes.
By the last order, this honorable court wanted to have some instructions from the respondents.
No, on the last occasion, you were indisposed, therefore we adjourned it.
Yes, my lord, I had to be out of station. Thereafter, my lord, the matter, on 14/11/25, the matter came before this court, my lord, and this court was pleased to ask the respondents to obtain instruction regarding the status of the detailed project reports in all those waste management plan. And apart from that, there is.
Have you,
Yes, my lord. On 30th of January, we have filed the affidavit.
have you given a copy to him?
Yes, yes, my lord, copy has been.
Yes, my lord.
Yes, he has only recently been engaged. So we just
Yes,
go through that response
Correct, my lord.
and then we shall hear.
Yes. Other two matters also, lordships wanted me to assist your lordships, my lord. Those documents of those cases I have already collected. Sometime, my lord, I'll assist. There are two other matters, my lord, 20 and 22.
All right. So here, we are
21
not
and
saying
22.
anything. Let this matter come up for consideration
Yeah.
on. After, no, not May. Sometimes in March,
Fine, my lord. Fine.
end of March, March में कोई date नहीं है, April. After the.
Fine.
24th April. Item 23.
Yes.
अपना rules को change हुआ था. My lord, as per the order dated.
Just-
Yeah, apologies,
We are just going through the orders.
my lord.
First, we must apprise ourselves
My
with the order dated 1/8/2025, passed by this court. Let us see first. Yes, you were saying something.
My lord, as per the order dated 1st of December 2025, my lord, my friend for the forest department had submitted that proposals are being undertaken, the process is undertaken by the forest department to come up with new proposals to counter the menace. And I understand, my lord, that the rules.
Appears for the forest department.
My lord,
Yes,
my lord, sir,
you have already filed an affidavit.
we have.
And what have you said?
What has happened was earlier there were some rules which were governing the field. There were some rules governing the field. They were set aside by a division bench of this honorable court because they were in the teeth of the Mines and Minerals Development Act. Because once stone is extracted from the mines, it comes out of the ambit of the act, your lordship. So those the rules framed under that act, your lordship, cannot be used to regulate stone crushers. However, an unnotified rules were produced before the court in those proceedings under the Air Act, your lordship. But since they had not been notified in the Gazette, the division bench was of the view that those rules do not have the force of law. So we were given liberty to frame rules if required. So now that process is underway, your lordship, the draft rules have been notified. And it is in the process of interdepartmental consultation.
That will also be nullified.
Mr. Kaustav Pathak, Standing Counsel, Environment, Forest and Climate Change Department, has submitted that a draft notification of within quote stone crusher establishment from operation, regulation and closure rules 2026 has been circulated for obtaining the views of other concerned departments. The views of Finance, Revenue and Disaster Management Department, Revenue and Disaster Management and legislative departments have already been received. Whereas the comments from Industries and Commerce Department, from our Mines and Minerals Department, Transport and Judicial Department are still awaited. The draft rules, Mr. Pathak suggests, takes care of the menace of limestone crushing. And with such rule in place, it would effectively curb illegal limestone mining. Awaiting the notification of the rules in question, the matter is adjourned to. May. But don't
It
sit
may.
over it. We need it.
Yes,
Don't sit over it.
very well.
On 8-5. Item 24.
I am for the respondent lordship.
So here's for the appellant. Mr. Sharma, you are appearing.
My lord.
Yeah, tell us.
My lord, here the issue is in a very narrow compass, my lord, and the dates might be very relevant. My lord, if your lordship can.
Did we pass any order on the last of? It's with respect to freezing of the account.
The freezing of the accounts, my lord.
And the title suit is pending.
Title suit is pending, my lord. Now,
What do we do? Here?
now, my lord, the dates are slightly important here, my lord, if I may permit.
Yeah.
Yes.
To start afresh. It's only a vague memory of,
my lord.
we have not said anything in our orders.
My
So
lord.
there is a vague memory of account having been frozen at the instance of two of the partners
Yes.
And
Frozen-
therefore the difficulty in making payment of
Yes.
CGST,
Yes.
entitlements or
Yes.
something like that.
Absolutely.
Yes.
In fact, there was a partnership comprising of 3 partners, my lord.
Hmm.
And the mandate of the partnership form
No, no,
as
3
well.
partners.
3 partners.
The appellant is one of the partners.
The appellant, there are 2 appellants, my lord.
Hmm.
The appellants are the partners, my lord. 2 of the 3 partners, and the private respondent is the 3rd partner.
2 of the 3.
Now, the issue is,
Yes.
now the issue is, my lord, that the partnership talked about any 2 of the partners having a right to manage the accounts of the partnership firm at the State Bank of India. 2 branches were there, my lord. Now, what had happened, my lord, was that presumably due to a dispute, which is now out in the open, one partner, which is the private respondent, preferred.
Who appears for that private respondent? Yours. All right.
There's one partner who had unilaterally preferred a letter to the State Bank of India to close the accounts. And the accounts were unilaterally closed.
Closed?
Closed. Frozen. Frozen, my lord. Frozen. I chose the wrong words, my lord. It was frozen. Pursuant to which, my lord, that the writ petition.
That letter, did it say that the 3rd partner wanted to have the firm dissolved?
No.
It was just like that.
Just like that, my lord.
Oppression and mismanagement.
Personal mismanagement, that was a letter. Initially, if your lordship may kindly come to page 46, my lord. Page 46. Page 46. The letters are dated, my lord, 6th of April, 2023.
What does it say?
It says, my lord, to the branch manager, State Bank of India, so-and-so branch, reference, account number, so-and-so of Pragati. Pragati is a partnership firm. Subject, stop payment from this account. Respected sir, this is to inform you that I am one of the partner of our firm Pragati and we had opened the above mentioned account in your bank. But another 2 had withdrawn huge amount of money since March 2022 from this account without informing me. They had misused the fund like Mr. So-and-so and Dr. So-and-so. They're neither partner nor supplier. Also, the Decca Enterprise is a fake firm. For your information, last 2 years, books of accounts not shown to me and keep me in dark. As a partner to
This letter, what happened to this letter?
this letter, my lord, this letter was identical to another letter at page 47 to another branch. Same letter, same date, my lord. Just the branch is different, man. Pursuant to that, at page 48 and 49, those respective branches of the State Bank of India, my lord, had furnished a letter dated 11th of April 2023, stating that with reference to the subject, one of the partners of Pragati, Shri so-and-so, which is respondent number 4, my lord, has submitted an application to stop the payment of account on so-and-so till further information.
To be on the safer side, the bank did this.
The bank did it.
To be on the safer side for the bank.
My lord.
Yeah.
That's what was done, my lord. Therefore, the account has been stopped as per the request of the partner. You are therefore requested to submit a mutually agreed consent to allow the operation of the bank. Now, my lord, will kindly come to page 30 of the appeal, my lord. Page 30. Page 30 is the prayer portion of the writ petition, my lord. A writ in the nature of mandamus should not be issued to the respondent authorities to allow the petitioners to operate the bank account number so-and-so opened at offices of the respondent number 2 pertaining to the bank account of Pragati, as well as all consequential and
Say a writ in the nature of mandamus should not be issued.
Because, my lord, upon the respondents to show cause as to why.
As to why. Okay,
Yes,
okay.
my lord. Yes.
As to why it should not be issued. What a defective way of
No, my lord.
framing the prayer.
No, my lord.
This is all right. All right. We had in the other jurisdiction from where I come from, we had framed a particular format and we said that don't use such whether it is this, whether it is this. You state the facts. No such complexities should be there. Should be straight. Whether mandamus, why it should not be
should not be issued to the respondent authorities to allow the petitioners to operate the bank account number so-and-so. And number 2 is an identical prayer, my lord, to operate the other bank account.
That's all right.
My lord, now my prayers in the writ petition were based upon page 33, my lord, will kindly come, my lord. Page 33. page 33 is the partnership deed dated 1st of December 2011.
No, just a minute.
My lord.
So this, you said my prayer, you appeared for the two other respondents, two other partners, no?
My lord.
Two other partners.
The two partners.
Two partners.
My
The
lord.
the one who had asked for closure of account is not that.
No, I am for those.
You filed this writ
I
petition.
filed, my lord. My,
Both of you filed the writ petition,
my lord. My petition was dismissed, my lord.
saying that it's why it should not.
I have grounds to argue, my lord.
Yes, then?
Yes, my lord. The page 33 is the partnership deed, my lord, the latest partnership deed between the three partners, my lord, the appellants and the private respondent number 4. Paresh Kumar Gogoi is respondent number 4. Nobokanta Bora and Purobi Deka are my clients, my lord, the appellants. Now, my lord will kindly come to page 37 for a moment. Page 37, management.
That any two of you could operate the account.
Yes. Now, since that portion of the partnership deed was not adhered to by the bank, and there was a mandate form which was bought on record by my senior friend.
This was, no, Mr. Patak, please. That argument, Mr. Sharma, sorry, Mr. Sharma, that argument does not hold water. Now, this term of the partnership deed is with respect to a situation when there is no dispute. Now, two of you could jointly execute and there would be no necessity for the third one to countersign the checks. It only refers to that. But in case of any dispute, two of you gang up together and one. We don't know whether you have ganged up or not. We are not making any statement with respect. But this is limited to that situation. When there is no dispute, inter se partners. So two of them can always operate. That cannot be the reason. Yes.
And
so then
the reason, the ground, my lord, your lordship is very correct that if there was a situation where multiple partners are gathered.
Otherwise, this is a complete stoppage to any third partner or one of the partners.
Yes, my lord. In fact,
to have the funds saved.
The Partnership Act, in fact, takes care of a situation like that, my lord. If your lordship, if I may kindly be permitted to read.
It's understood.
Under section 43, the respondent number 4 had absolute authority to prefer a notice for dissolution of the firm. And under section 53 of the Act, my lord, the dissolution of the firm would have barred any of the partners from using the name of the partnership after that notice was received by the other side, the other partners. That was a measure that we had taken prior to filing of the title suit. The title suit.
No, come stepwise.
My lord.
So this is now.
Yes.
Then what is clause 10?
Now, this was one of our grounds, my lord. And
clause 10?
Clause 10. That the partnership shall open account with any bank or banks in the name of partnership, namely Messrs. Pragati.
That's all right.
Yes.
That gives the passage.
My lord.
Then what happened?
Then we approached this honorable court, my lord. We approached this honorable court because
against the order passed by the bank.
Against the order passed by the bank. Because
what did the court say? Because we have followed.
Yes.
What did the court say?
The court had stated that
shows that order.
My lord.
Just take one.
My lord, the operative.
One second, sir.
My lord, my lord.
Partnership Act then. Yes.
My lord. Now, the Honorable Single Judge, my lord, had stated that since there was a title suit pending, we could not have approached this
And title suit was filed by whom?
by us, my lord.
Okay.
Now, the title suit, my lord,
Mhm.
the title suit was filed after, if your lordship may kindly come to page 53, my lord, for a moment, my lord, page
What
53,
was the prayer in that plaint?
for rendition of accounts, my lord.
Only for rendition,
Rendition of accounts.
not for dissolution of firm stood
The
dissolved
firm
on
stood dissolved,
23/5/2023.
yes, my lord, after the letter
And
dated
you filed title suit when?
31/5.
Yes.
So the title suit was limited to the rendition of accounts that would be applicable to have been filed any date after 23rd of May.
But today what happens?
Today, what happens, my lord, is that there is a point in time where,
Tell me one thing.
my lord,
Now, section 53 of the Partnership Act, can it be enforced now under the orders of the trial court,
no, my
the
lord,
civil court?
section
Here,
53,
Mr. Sharma, answer this question.
My lord.
Now the firm stands dissolved.
my lord,
The litigation is pending for rendition of account.
my lord,
Now, everything, any party who has to make payment or do whatever can approach the court, take leave of the court for operation of that account, whatever. But now the court, the learned single judge is absolutely right.
my lord.
You cannot come to this court now for all this. Everything for rendition of account, all right. Or against the dissolution of the firm, there is other forum, not here in the writ jurisdiction. The court is right.
No, the bank,
Hmm.
the respondent bank, my lord, my submission was limited to the extent. The
Tell me
respondent
one
bank,
thing, 53 can be enforced or not?
my lord, 53, if there are obligations due on behalf of the firm
How do
prior,
you say so?
my
How
lord,
do you say? That if the obligations are left, that will be decided pro rata basis or whatever it will be done. Otherwise, how are you interested in the firm?
no, my lord,
That stands dissolved.
the firm stands dissolved after the dissolution, the letter was received by the other side, my lord. Now, my lord,
Unless you have some legal arguments on
No.
facts, we are
the
absolutely
legal
clear.
argument would be, my lord,
Hmm?
that my legal argument would be that the date the firm was closed, the account was frozen. That was not mandated by any section of the Partnership Act. That was only at the behest of a
Correct. So
simple
it was,
letter.
it was a wrong order.
It-
But today, after the
My
dissolution,
my lord,
whatever has happened, it
My
should
lord.
not have been done. Or
My lord.
you should have been noticed.
My
And then only it should have been done.
my lord.
Correct. But now the situation is different. It has any party can restrain the others from using the bank.
Because the bank is effectively the partnership firm is effectively no longer in existence, my lord. That is an absolutely admitted fact, my lord. There is no
Come to
dispute. with that.
53.
My lord, 53.
For any relief now, go before the civil court.
No, because what has happened, my lord, that
No,
there
but
are
how
news.
do we permit you? Tell
Yes,
me.
that is true, my lord.
Under what provision do we
That is true.
permit you
That
to
is true.
operate the account? Two of you together.
To the extent, my lord, to the extent
We
the
agree.
bank's accounts
We
stood-
agree to your submission.
My lord.
It should not have been closed unilaterally because the terms of agreement, the
Yes.
partnership agreement does not permit.
My lord, my lord,
All that the bank should have done was to see.
my lord,
Because the mandate to the bank was that two of them can operate.
my lord,
The bank cannot go by a unilateral
my
letter.
lord, my lord,
But now it was done. You could not do
my
that.
lord.
You did not come before this court at that time. By the time you
My
would
lord.
have, by the time you approached this court,
In fact,
before
our
the
petition was
the petition had
Sir.
already, the firm had already been dissolved.
My
So
lord.
with the efflux of time, your your cause of action got diluted to the maximum.
My lord,
So go before the civil court.
the lordship will observe that.
What
my
we
lord.
will
The
observe?
lordship will observe that.
You have a right.
I have a right, my lord. I have a
That
right,
is, why do we put fetters on the powers of the civil court?
my lord.
Take that. We have heard Mr. M. Sharma, an advocate for the appellant, and Mr. B. Chakravarti. Who is the senior of you three? All three of you appearing for the sole partner who has got the firm dissolved.
My
You
lord,
are you are Mr. B. Chakravarti and SP Bhattacharya and A. Khasnolush. Khasnobish. B.
I am
And-
K-less, my lord.
Huh?
I am K-less, my lord, for a respondent 1, 2, 3 bank, my lord.
All right. We have heard Mr. M. Sharma, an advocate for the appellant, Mr. B. Chakravarti, assisted by Mr. SP Bhattacharya and A. Khasnobish, learned advocates for respondent number 4, and Mr.
K-less, your lord.
K. Das for respondent number 1 and
1, 2, 3, my lord.
response number 1 to 3. The challenge in this appeal is to the judgment dated,
My lord, 22/4/2024.
to the judgment dated 22/4/2024, passed by a learned single judge of this court in WPC number 3946 of 2023, whereby no interference has been made at the instance of the appellants against a decision of the bank where a firm account had been opened, which stood frozen on the complaint of respondent number 4, on the complaint and asking of respondent number 4. The facts reveal that a partnership firm
It's 33.
partnership firm, a partnership deed was executed between 3 partners, 2 being the appellants, for establishing a firm under the name and style of Pragati. According to the partnership deed, all the partners had agreed to take active part in the management and conduct of the partnership business and its other affairs as working partners of the firm. It was also stipulated in the deed that any 2 of the partners could jointly execute any agreement, etc., with any other party on behalf of the firm. So far as operation of bank account in the name of the firm was concerned, the partnership deed clearly stated that the firm shall open an account with any bank or banks in the name of partnership, namely Messrs. Pragati. And all checks drawn on partnership account shall be signed jointly by any 2 of the partners of the firm. Over a passage of time, dispute arose between partners and the respondent number 4, sensing foul play at the hands of the appellants as partners, wrote a letter to the branch manager of the 2 of the branches of State Bank of India, where there was firm account, to freeze the same / stop payment on account of the possibility of siphoning off / swindling the joint account of the partners, joint account of the firm. It further appears that on 23/5/2023, the firm stood dissolved at the instance of respondent number 4.
My lord, no, my lord. of the appellant number one.
At the instance of, at the instance of appellant number one, Mr. Sharma has however contended that the decision to stop payment or to freeze the firm account was passed unilaterally by the bank, by the two branches of State Bank on 11/4/2023, without even intimating the appellants. This could not have been done, as before the dissolution of the firm, there were certain payment liabilities of the firm which obligation could not be discharged for the reason of the account having been freezed by the two branches of the State Bank. A title suit also appears to have been filed by the appellant for rendition of account, which is still pending consideration. Thereafter, the appellants approached this court seeking a writ of mandamus
Page 30, my lord.
directing the respondent bank / respondent number 1 to 3 to allow the appellants to operate the bank account opened at response number, opened at branches bracket respond number 2 and 3. And the reason for preferring this petition was that the obligation to pay certain dues to the state entities was still surviving. The learned single judge, on finding that the appellants had preferred the title suit number 323 of 2023, wrongly invoked the jurisdiction of this court under Article 226 of the Constitution. And held that invoking such jurisdiction at the instance of the appellant was an abuse of the process of the court. However, it was also observed by the learned single judge that the judgment passed by it shall not preclude or debar, shall not preclude the trial court in seizing of the proceedings of title suit number 323 of 2023 to pass any such decree or order as would be permitted under law for appropriation of the balance available in the two referred to bank accounts with the response number 2 and 3 in respect of MS Pragati and the Pragati, the partnership firm of the appellants, and respond number 4. Respond number 4. With the dissolution of the firm and the pendency of the writ and the pendency of the title suit, even a right which could be invoked under Section 53 of the Indian Partnership Act 1932 would be available to the parties, which available to the parties. Presently, since the firm has been dissolved, when the firm stands dissolved and the dispute is pending consideration before the civil courts, the learned single judge rightly did not interfere with the decision of the bank and did not direct for making the bank account of the firm operative because two of the partners could jointly manage the account. That it should not have been, that such decision should not have been taken unilaterally by the bank on the complaint of one of the partners is something which cannot be agitated at the present moment when a civil suit is pending and the firm has been dissolved. Firm stands dissolved. There is no merit in this appeal, same is discussed.
Pleasure, Lordship.
Item 25 and 26.
Ready? You're ready? You're ready?
Ready.
So we come back.
Lordship.
We come back after lunch?
Right.
Or if you can finish it in 10 minutes?
I can finish within 5 minutes, but my friend will tell him not.
Mr. Chanda is, he knows his facts very well.
Lordship.
So he might not conclude within 5 minutes.
Within 5 minutes.
So we will hear you at 2.
Lordship.
Item 25 and 26.
Lordship, item number 26 may be taken up first. That other day I was making submission on the basis of 26. Lordship.
We already.
Just to recapitulate, Lordship.
Just a minute. Very quickly.
Lordship, matter relates to the cancellation of selection, Lordship. Lordship, on 5/8/19, a notification was issued. 5/8.
Give us the pages.
Lordship. Page number. Dates, Lordship. Dates. Notification, Lordship. The employment notification, Lordship, page 13, Annex A.
What is this?
Relates to the appointment of from post of GDS, that is Gramin Dak Sevak, to postal assistant and section sorting assistant, Lordship.
Limited competitive.
Limited Lordship, LDC. Accordingly, Lordship, written test was held on 15/9/19 and data entry test on 9/2/2020. That thereafter on 10/12/20. 9/2/2020. Lordship. That on 10/12/2020 we cancelled the selection, Lordship.
When did you cancel it?
10/12/2020. That will Lordship find at page 17, Lordship. Against this, they moved the land tribunal, Lordship.
Let us see the reason why you have cancelled.
Lordship. The judgment is at page 95, Lordship.
No.
Or 17, Lordship, cancellation. Page 17, Lordship.
Read.
This is regarding finalization of examination process related to LDC from GDS to PA and SA for the year 2015-16, 16-17, 17-18, 18 from 1/4/18 to 31/12/18, and 2019, that is 1/1/19 to 31/12/19. Now pausing for a moment, Lordship, it itself is against the Lordship service rule, because service rule says every year it has to be notified. So you cannot club the vacancies. Year was spent a lot to have been maintained, Lordship. So this goes against the spirit of the service rule, Lordship. I am married, Lordship, further.
Can you argue that?
Lordship.
Can you argue that?
Yes, Lordship.
Now, all those years, preceding years, if we had not filled up the post, then what is against service?
Lordship,
keeping the posts vacant. Anyway, we'll deal with it. What this? Don't raise an argument which on face of it will not be acceptable.
Lordship, the point of
you are to be faulted. No, who is to be faulted?
Lord, that's true. We are faulted, but point of law cannot be ignored, Lordship.
Don't raise that ground. No.
Anyway, Lordship. I am directed to convey
What would
the,
have happened? If say for 5-6 years it would not have been done, then in the last year, what do? You keep other things,
no, would have been year-wise lordship, then
Anyway, there is no logic behind it. So therefore, we don't
Lordship.
accept that argument. So
I-
abnormal vacancies, abnormal means?
means,
No. Abnormal vacancies
For-
is
means
what I
the-
understand from the expression is,
lordship, they have taken a
please listen
more
to the
vacant.
court. Abnormal vacancies means that more number of seats notified than
Than what-
actually which exists.
Exactly, lordship,
So when you don't talk about clubbing,
lordship,
talk about vacancies which were wrongly notified.
lordship.
What do you mean? I mean, either of the two. You tell
Lordship,
us.
we have justified in a
Vacancies-
report. We,
Anyway, then what happened?
lordship, after cancellation, they moved the tribunal, lordship, and tribunal allowed that,
Who moved the tribunal?
the candidate who appeared in the,
The candidates had passed.
Yes.
result was not declared.
No, but how did they know that they had passed?
They
You
have-
are not telling us the facts.
They approached the court to declare the result and take action accordingly. That was the prayer, lordship.
So the
Written was declared.
written examination test was declared.
Declared.
They had passed.
They passed.
But after the skill test, that also marks was
That was also held.
that was
That
declared.
was held.
Then held and marks declared.
Marks, lordship, that aspect is not clear from the pleadings, lordship.
Arguing then. What are you arguing?
Before declaration of the result, we have cancelled the it, lordship.
No, but did you disclose the final
No,
tally?
no, lordship.
Or did you disclose any one of the tallies?
No, lordship.
No.
No.
So how did you take the skill test of all persons?
On the basis of written test, who passed
So
the
written test result you had declared.
Lordship.
But this after this nothing.
Nothing, lordship.
Okay. Then
Then they approved and that was allowed.
so
Lordship.
no. If you argue like this, then we will perhaps go through the brief or ourselves. So
Lordship,
Chakravarti, please don't miss out on any step. Now let us come to the cat.
lordship, the order, lordship.
Order,
Page 95.
page 95.
95. Start from 95, lordship.
The questions that this court is asking, those are the basis on which the decision of cancellation of examination would be tested, whether it was correct or it wasn't correct. But you are not saying here we have not declared. You must understand why the court is asking that question.
Lordship, no.
It's not for ascertaining facts only. Yes, let's see if the judge has, if the tribunal has noted down the prayer made in the OA.
Lordship.
Let us see. And how many of them had approached? How many of the
Lordship,
petitioners had approached?
Lordship, I'm
Sir, you are not ready.
six respondent is
I
there.
don't think so.
6 respondent in this
We
case.
are not asking in this case. How many persons moved the tribunal in OA?
Seventeen, lordship. In one of the OA is the 17% and the other, lordship,
How many
6,
were
17 and 6.
how many had participated in that limited competition?
That aspect is not clear. lordship.
Mr. Dud, how do you think that we will justify your action or we will not justify? What are you talking, sir? I asked you no on that day, please come prepared.
23%,
So
sir.
your decision making with respect to cancellation.
Lordship.
That also when the vacancies were of yesteryears, previous years.
Lordship.
And you say abnormal vacancies, you don't talk about
Clubbing.
any mismanagement at the examination or any.
No, that is also one of the ground, lordship.
Have you said that? Then we will know how many had appeared. What discrepancies?
Lordship, that has been explained in the WS, lordship.
You want us to keep on reminding you that you are not prepared to the.
No, lordship, that has been stated in the WS, lordship. Page, lordship, may come to page 88,
You
lordship.
expect the appellate court to read the written statement,
Lordship 88, we have stated so, lordship.
and we ignore that. Where is your pleading in the memo of appeal?
Lordship.
Anyway, first we begin now.
Lordship, can we come to
Are we asking many questions than what
No,
is
lordship, no,
required?
no. Certainly, lordship has a right to ask question.
No,
lordship.
that's true, but then you look disoriented today. Why?
Lordship, can we come to our
a
WS,
minute.
lordship, we
Just a minute. This is because we expect much more from you. You're second
Lordship,
government council, no? we
Certainly.
and
I'm not
we have-
senior.
We have seen you arguing. You are always prepared. Why today you are
Lordship.
not answering? Yes,
Lordship, can we come to our?
1 second.
Result will be clear.
Mean that they were qualified. How was that statement made before the tribunal? Come to paragraph 2 at page 105.
Lordship.
Last line, the applicants on being successful in the written test also appeared in the said computer test and they claimed that they were qualified in the computer test too.
Lordship, that's my friend will be able to say.
No, you tell us whether you had declared, you had not declared it.
No, Lordship.
Don't run away from answering.
No,
If
sir.
you don't know, you say you don't know.
No.
Huh. Full form of GDS is?
Gramin Dak Sevak.
And when did you come out with a new notification for holding again for 2020? During the pendency of the OH?
Lordship. Lordship, page 83, Lordship. This states that we have cancelled and a fresh notification will be issued in due course, Lordship. Page 83.
Show us at this stage, show us that's a letter dated 2/2/2021,
2/2/21.
which perhaps Mr. Chanda would.
Yes, they have annexed into their affidavit, page 585.
Where do I get it?
In their affidavit also.
उतना बड़ा effort किया.
Page 585.
I will tell you that. It's context me. Okay. Government of India Ministry of Communication Department of Post to the CCMD, written by Assistant Director General. You don't know that. This is neither here nor there, nothing. Issue but
That letter might have.
Now, because of this stay order operating, you never filled up any post, even if it occurred or
No.
in PA grade.
No, Lordship.
Nothing. So for 6 years, nothing.
Lordship.
Yes.
We tried to move a MA that was rejected, Lordship.
So conclude your argument.
Seeking a stay vacation that was rejected.
Conclude your
Now, Lordship, my submission is that, Lordship, there was 3-4 count on which the tribunal allowed the petition. First was abnormal vacancies. There was inconsistency in our notification than what has been stated in the written statement. So that is one of the point taken. Second is that letter was relied, Lordship. In my humble submission, that cannot be the ground to Lordship. This is an inter-office memo to which they are not accessible, Lordship. That cannot be given any right.
Do you deny that letter?
No, we are not denying that letter, but it is an inter-office memo between two.
So yes, the applicants have flagged this. In fact,
they have not obtained through RTI also. They have not
that is
obtained.
no answer, sir.
Lordship, and that
Now that letter was written under what circumstance?
Lordship,
You have not checked it.
No, Lordship, someone
look at this data here. Just need to report the report on the conduct of the by director of the So this observation was made post the cancellation.
Post cancellation, Lordship.
You don't require to go to this.
No, because
under what circumstance this letter
Lordship, Chief
was
Postmaster General is the competent authority. Here, he is the head of entire Assam, Lordship. He has power to take decision, and he took decisions. He issued the notification, employment notification.
The Director of Post
the Chief Postmaster General, Lordship. Kindly, Lordship, see.
Cancellation order is you had shown it.
Also on the director of the on the authority of the Chief Postmaster General, page 17. Cancellation done by under the authority of CPMG, Lordship. Notification of employment also on the authority of CPMG. He is the authority who can take decision, Lordship.
Without approval of the headquarters.
Yes.
Without approval of the headquarters, my lord. They have written it to give a clarification because under the same notification, under the same notification, all over India, this examination has held.
Now you say.
And then the headquarters says it is flimsy ground. Lordship, that para 18, it is quoted. This letter is quoted in para 18 of the impugned judgment, my lord. Para 18. Impugned judgment is quoted in para 18, my lord. I am reading it, my lord.
Yes.
And in tone with this, my lord, the tribunal has passed the judgment in tone with the letter of the headquarters. And they have suppressed this letter, and they have also suppressed another affidavit whereby they have disclosed the actual vacancies before the tribunal, pursuant to a direction by the tribunal. That affidavit also not enclosed in the writ petition. I will show your lordship.
What is the vacancy?
What is the vacancy position? They have 3 members committee was constituted. At the my lord, request of the tribunal, 3 members committee and actual number was submitted by an affidavit, my lord. By an affidavit. That also they have not disclosed in the writ petition.
Mr. Chanda, please. The advertisement was issued for that competitive examination disclosing 125 vacancies.
125.
And 125, this was dated 5/8/2019.
19.
Correct?
My lord.
Where do we find it?
My lord.
Page?
That your lordship will find page. Advertisement page 13 onwards. 13 onwards.
This 5/8/2019. And where do we get it that when this report was submitted, there was further constitution of a special committee to decide about the vacancy position?
That your lordship will find in my affidavit. In my affidavit. In my affidavit in opposition.
Page?
Page. Lordship will find 579.
Where? This affidavit was filed when?
Filed before the pronouncement of the judgment. By on a direction by the tribunal, a 3 members committee was constituted. That your lordship will find, lordship got it, page 579. Yes. Then your lordship may come to page 581, para 3. Para 3 in the bottom. In the bottom, my lord. That during the course of hearing of the Honorable Tribunal has directed by order dated 2/5/2023 to make a comparative statement of vacancy, and in compliance to the said order, the competent authority has constituted a 3 members committee of senior officers to prepare the statement. The said committee has met on several dates, examined the statement of vacancies, and submitted by recruiting divisions unit, and has prepared a comparative statement. A copy of the minutes of the said committee along with the enclosures are filed here too. Then your lordship may straightway come to page 584.
They say that if other divisions are taken. So this committee also says that the vacancy is 75.
75.
That is 50 less than what was notified.
122.
How could it be worked out then?
Then my lord,
Can it give us any law which says that you notify the number of vacancies and then you
no, their headquarters suggested that you recruit their affidavit, yeah, that letter, my lord, 585. That letter. It says that you recruit whatever vacancies are available.
No, how can that be possible? How is that possible under service?
You on merit, my lord, on merit. Whoever's qualified, only 75 to be.
That's not the way cookie crumbles, especially in appointment matters. If that be so, there would never be any justification of being very specific in the advertisement that these are the number of vacancies. Depending upon the nature of vacancies, that is how the marking standard goes.
My lord, we have qualified in the examination.
We
have
The
qualified in
question
the
is that it is less. Suppose this letter would have been filed. The department would have said that no, we don't follow this. How can we do that?
My lord, your lordship, I'll show.
Suppose some unsuccessful candidate, just a minute. Suppose some unsuccessful candidate would have questioned if this letter would have been followed of giving appointment to those persons considering that vacancy was only 75 and not 125. And persons who would not have gone into that list, if they would have challenged and said that, well, notification was of 125, they have announced only 75.
My lord,
what exercise?
Not a single complaint is there. It is in the absence of any complaint, it was cancelled. In the absence of any complaint, it was cancelled. Because
that the tribunal has taken note of.
No, there is no complaint from any corner.
They don't repeat things. You have said that.
My lord.
There is no complaint.
No complaint.
That is what the letter also says, that even if there was no CCTV surveillance, there was some report. There was no complaint.
And that was stamped as flimsy, my lord. Flimsy, my lord. And apart from that, my lord, only one thing. Rajya Sabha, Lok Sabha.
Who appears?
Lordship.
Has Assistant Director General DE been made a party?
My lord?
No. No, no.
Mr. Chandra, we are slightly jittery at the concept of, validating the entire examination process now after 6 years.
My lord, lordship will find, even your lordship will see.
Because of all this litigation and hard stand, up till now, the vacancies have not been filled up.
My
In
lord,
fact, that suits them because they say that at that time there was no vacancy, zero vacancy.
zero vacancy, and then on different occasions, different vacancies were placed before the tribunal, your lordship.
That to that extent, they have made a wrong statement.
And not only that, Rajya Sabha also, lordship will kindly type 354. Rajya Sabha have and Lok Sabha, they have given.
Who is the superior authority, CPMG or director, or D?
Assistant DG is superior authority. Superior authority. And it is the ministry. It is the ministry saying like that.
How come the Union of India has filed an appeal?
That is what?
Through CPM.
That is what I raised, my lord, on the other day. That assistant secretary, assistant director of staff cannot file a suit. They cannot file a writ petition on behalf of the, when it was rejected by the ministry itself. And in Rajya Sabha, Lordship, I have, minister has vacancies shown much more higher. 324 and 286 on the same year, for the same year. That is on record, my lord. I brought it on record. Rajya Sabha minister has replied, in Assam Circle, vacancy is this much.
That's all right. No problem. Or because those vacancies have not been filled up, job को देखना है। करेगा proper compute करेगा vacancy यहाँ उसको करेगा today one tell us what is the present vacancy so that we give a directive. Here we see the we can't take that exercise. Chanda, we are sitting in 2026 and discussing this up till now. What you should have done was that against the interim, the state should have come, the union should have come against the interim order to expedite the process, but they were not interested. They were not interested for the reason that there was no direction by the tribunal to give the appointment. It was only a direction not to give effect to that cancellation or recall order. Right. So they were very happy with that situation because according to them, though the vacancy may have been 75 or 125 as it was notified, but in fact, because of the surplus in other division, there was no vacancy. That's the way they have put it. So therefore, everything was delayed. You should have gone before the tribunal to say that, well, years after years are passing by and you have not even asked. It was better that please conclude this proceeding and direct for afresh if you're not interested.
My lord, after burning midnight candle, midnight candle, my lord.
After
Burning midnight, we have come out successful in the written examination. We have come out successful in the written examination. We are expecting that there should, it is because of the lapse of the department.
It is
this vacancy notification is not the fault of the
employees. When are we suggesting that it is your fault? Question, Mr. Chanda, is that you may have burned midnight lamp. What is Yucumbrate? There was the word Yucumbrate is burning midnight lamp. Yucumbrate. You have burnt midnight lamp, all right. You were successful, all right. But we don't have to look at your rights only, the competing rights of others who may not have passed. They will say that this entire process is defective.
No, nobody has come out with such complaint, my lord.
Sir, nobody has come out with complaint because the exam by that time, before they could come out with complaint, they have already taken a decision.
There is no complaint from any corner, my lord. Any corner, any complaint, no complaint.
Let you be appointed, thereafter there will be a complaint challenging this order.
My lord.
But in any case, in 2000, after about 6 years, we are not inclined to allow this direction to be sustained. That's our view.
My lord, I am referring to judgments that assistant director of staff cannot file the writ petition. Two judgment, one of this honorable court and one of this honorable Supreme Court. They cannot file the writ petition.
इस रिपोर्ट में क्या है? दोनों मिलके सब Why don't you appeal? Why don't you appeal to the, why did you go to board? You should have called, you should have told the ministry. You should have made a representation to the ministry. No, we are not doing it.
And my lord,
Both of them did not. Yeah, maybe. Both of them did not do it. It's समझ में होता है। This judgment is on. It has to be cancelled every time that we have, every time that there has been a discrepancy in the notified number of posts, the examination process has been cancelled. You show one judgment which says that no, this can be rectified. Show me one judgment, Mr.
my lord, I am East Coast Railway. I am relying on East Coast Railway that is in the bunch of the of my affidavit. East Coast Railway before cancellation.
East Coast Railway.
Yes.
What does it say?
It is a Supreme Court judgment, my lord. It is a Supreme Court judgment.
Where do we?
Bhatat Mahadev Appa Rao, page. It is started from page.
Which document?
In my affidavit in opposition, I have included the judgment. Page 588. 588.
Affidavit में judgment लगाते हैं. That you should keep handy, pull out. Right? When the court is asking, you should give. You start quoting the judgments in the affidavit, then it will be very difficult. Are these the rules of pleading?
My lord, 597. Relevant page is 588.
It is to handle this voluminous thing. You should have given. ये लोग खूब प्रेट तो क्या बता ये होता है ना वेरी गुड
Judgment of the party. Just.
ये तो ये तो फोन कॉल करो कितना है ताकि वो अपनी
Relevant para 26.
Just a minute.
26, 28, 29, 30, 31, and 33. Page 5, page 597.
Page?
Page 597. Para 26, 28.
We are asking something else.
No, yeah, my
We
lord.
are asking with respect to, this is with respect to application of mine giving proper reasons. We are asking that if the notified vacancies are less or more, would the examination process muster the scrutiny, pass the scrutiny of the court of law?
Their headquarter ministry is saying.
Forget about headquarter and ministry, sir. For the time being, you please do this. Show us any judgment which says that on that ground examination cannot be done. It's a mistake. It's their mistake. It is not our mistake. Do you have a right accrued in your favor because you were successful?
Right of consideration is there, my lord. Right of appointment is not there.
Right of
Right of
consideration
appointment is not there. Right of consideration is there.
Who is stopping you from being considered?
No, my lord. What happened?
Anyway, you make your arguments. We are not here to discuss with you.
Pilot is asking, you are only relying on the understanding of the higher authority. You are asking a judgment where it says that even if these vacancies are notified, post of vacancies are less than the notified vacancies, the selection proceeding can continue and it will not be.
I'll place that judgment. I'll place.
Mr. Chanda, logically,
Ah.
we are relying more on CPMG's decision making rather than ministry. Ministry is going on general. Look at the suggestion they have given, that it could be worked out, it could be rectified. Do you think it?
I'll bring that, I'll bring that judgment also, my lord.
You will not get any.
I'll get,
Rather you-
I'll get a judgment, my lord.
No,
I'll try to, I'll try, my lord.
I will tell you, rather you will get decisions to the contrary. In fact, in the judicial system, judicial service appointments, we have cancelled so many examinations because there was some mismatch in the actual vacancy position.
Lordship may give me 1 week time, 1 week or 10 days time, I'll find
I
out a
will
judgment.
give you time till eternity, but the only difficulty is.
I'll bring it out. I'll bring it out. I'll bring it out. And my lord, and my lord, my last submission will be the person who has cancelled this examination, who archiving is the chief postmaster general, archiving. The conduct of the archiving, why it was cancelled? Conduct of the archiving, one judgment of this honorable court, division bench of this honorable court. Just I'm of this conduct, the person or the chief.
Look into all this.
No, why I am saying, my lord, what he has done.
Suppose CPMG would have been dismissed from service.
No, what he has done. Inquiry committees, inquiry officers were summoned to his
We can't see that.
No, his conduct, my lord, who has cancelled it with a vested interest.
Conduct dekha kya kare?
Vested interest, because your lordship will find his conduct was reflected and this tribunal upheld
Mr.
his
Chanda,
conduct.
all this is not going to cut any ice with us. Because we know the law that if the vacancy position is wrongly notified, the moment it is corrected, then the entire system gets a jolt.
Well, I'll bring this judgment.
May not survive this scrutiny. That's my. We have all sympathy.
I got your lordship point.
We have all sympathies for you, Mr.
My
Chanda.
lord.
They are.
We are suffering for 5-6 years, my
Just
lord.
a minute, because of your doing. They are, because you are very rigid. Or for the reason that you have passed the written examination and you don't even know whether in the skill test you have been successful.
For the serious lapses
Just
of the
a minute.
department.
They would have found themselves in difficult position because even before all this order of tribunal, they had notified another vacancy and wanted to conduct an examination. But that was stayed.
No, this is subsequent vacancy, 2020, not 19.
Subsequent vacancy.
No, subsequent vacancy. These are not 19 vacancies.
All right. So what happened to 2020 vacancy?
20 vacancies they recruited. 2021, all this recruited. All these appointments were made. All these appointments were made. We are suffering.
No, ye to gadbad hai. This is bad. And 2020, 21, all
were appointed. And we are suffering in spite of qualified in the examination.
You should have taken this ground. Now we have on a different thing that nothing has been done. 2020 vacancy.
All
means where have you said so?
No, my lord, all the examination were because some of the applicants were also qualified in those examinations.
Just a minute, Mr. Chanda. So when 2020 vacancy were advertised, you would also have got an opportunity of participating.
No, some of them applied.
No.
Applied.
What happened?
Some of them also got selected.
Out of 20. Oh, you did not apply, or you must have applied, you would have failed.
My lord, here your lordship will find.
Yeah,
We'll
forget
get
that.
1 year back,
Just a
alia.
minute. The vacancy position of 2020, when it was notified, did you participate or not?
Oh, my lord, some of them are definitely participated.
From
all the applicants have participated or not, that I cannot right now. I cannot say. I cannot right now say.
So
but some of them have participated definitely.
Therefore, you cannot claim that you have been prejudiced to that account. What we were.
We will be getting 1 year back, my lord. This appointment we will get 1 year back then. This appointment we will get from 2019. It is 19 vacancy. We will be senior to them. We will be senior to them. And 20, 21, 22, all these have been, my lord.
Mr. Chanda, you try and understand. It will create further anomaly for the reason that you will be senior to those appointed or those promoted in the cadre of PS and PA without even being born in that cadre. How that seniority will be decided?
Because of, for their lapses, my lord, should we suffer? For their lapses.
Therefore,
For their lapses. And I'll place the judgment, my lord, as your lordship said, that if the vacancies are wrongly notified, I'll try to place.
entire system gets a jolt. It goes.
My lord, for their misdeed,
For there, but it
for
has-
their misdeed, whether we should, employee should suffer.
file a suit for damages. We are passing an order under Article 226.
My lord, I'll place that judgment, my lord. Your lordship may give me some time, I'll place that.
We are in no hurry to dismiss your case,
My
to allow their case. They have acted in most irrational manner. The only difficulty is that let us not pass an order which will create problems in the service jurisprudence. We are not going to tinker with law for Mr. Chanda.
Right.
The law as we understand, we are not going to do it for you. Even though you had elucubrated 5 years ago.
Even this repetition, my some.
That communication from the head of it is not decisive. They are not saying that you have wrongly cancelled it.
Yes, that is what exactly.
That was a suggestion. That suggestion was not accepted.
And tribunal, my lord, in the light of that, the tribunal has given a direction.
Look at this, Mr. Chanda, we will accept your contentions. We might. We are not giving you an assurance. We might accept your contention with respect to this, that even if the vacancy position has wrongly been advertised, it can be rectified midway. Correct? This Prakash Pathak is clear, it will not be. So this is not a recruitment, it's an examination for promotion. Nonetheless, with respect to the other discrepancy which they talk about in a vague manner, we will ignore that. But you tell us the law that with the wrong vacancy position, does the examination process survive?
I'll try to place.
Then we might start thinking in other way.
My lord.
Otherwise,
my lord,
what happens? Suppose you get appointed against the quota and vacancy of 2015, 16, 17, 18, 19, and 19. You would then come out with a prayer for placing you senior in the civil list with those persons who have passed in 20, 21, 22, 23, 24, 25, 26.
Lordship may put necessary restriction in that order.
Would it not be anomalous?
No, your lordship may put
born in
reasonable restriction. Reasonable restriction, lordship may put in that order.
You will be put in the last.
Yes.
This is
that also. But I will place that judgment, your lordship. Even if the vacancies are notified, I will try to place before your lordship.
Behaving like CPMG or the tribunal. If we do all this, if you have a right, you have a right. Finish.
My lord, I'll place that judgment, my lord. I'll place that judgment.
You have a strong case, Mr. Chanda. We don't get disheartened. You show us the law.
My lord, I'll show.
My understanding is.
My lord, I have a strong case, my lord. I believe.
You have.
I believe, my lord.
You have a strong case, but the difficulty is that
because of the
in the judicial administration, I have had the experience of going through several decisions which says that this anomaly cannot be rectified. If wrong vacancy position is notified, the entire process has to be recalibrated. That is how I have dealt with all judicial appointments during my time. Maybe I committed a mistake, but nobody corrected it. The matter never went to any superior court. And you find out.
I'll find out. I'll find out. I'll find out.
देखो लिखो We have heard Mr. E. Chakravarti for the petitioner / Union of India and others, and another, and Mr. M. Chanda for the respondents. Next, the Assam Postal Circle had issued a notification on 28/2019 inviting applications for a departmental competitive examination. The examination was open to multitasking staff, bracket MTS, and Gramin Dak Sevaks, bracket GDS, for recruitment to the cadre of postman / mail guard against vacancies for the year 2019. The selection process was to be conducted in 2 phases, namely a written examination followed by a data entry skill test. The records reveal that the written test was held on 29/9/2019 and the respondents were declared to be successful and were called upon to subject themselves to the skill test. The skill test also was conducted, but the results were never declared. Because of the delay in declaration of the result, the respondents approached the tribunal, Central Administrative Tribunal Gauhati bench, seeking a direction for declaration of result. While the aforementioned OAs by different applicants were pending, by a notification dated 10/12/2020, the entire recruitment process was cancelled on the plea of the advertisement notifying abnormally high vacancies, meaning thereby that more vacancies were notified than what actually existed, as also for the reason of non-observance, reason of non-adherence to the mandatory postal directorate guidelines requiring maintenance and preservation of CCTV surveillance during the examination process. Thus, considering such lapses as grave and prejudicial to the fairness of the selection process, such a decision to cancel the entire examination was taken. Aggrieved by such cancellation of the entire process, paragraph 8, some of the candidates / respondents approached the tribunal by OA number 5 of 2021 with a prayer for a direction to declare the results of the examination and to appoint them against notified vacancies. In the aforenoted OA, an interim order was passed, putting in abeyance the implementation of the order dated 10/12/2020. In the meantime, the vacancies for the year 2020 was advertised, in which many of the applicants also participated. The results were declared. Similarly, for the successive vacancies occurring in succeeding years, the limited departmental examinations were held. It appears at this stage that the respondents herein either had not participated in the subsequently advertised vacancy, or had participated but had not come out successful. In any view of the matter, while the The report was tabled before the Ministry of Post, before the Ministry of Posts and Telegraph regarding the
Minister of Communication.
Ministry of Communication in the Department of Posts. Ministry of Communication in the Department of Posts. What did I say? While regarding the selection process all over India and bringing to the notice of the department that for notifying vacancies more in number than what existed and non-adherence to mandatory postal directed guidelines while conducting the examination. The entire examination process for Gauhati circle was cancelled. An objection was raised by the department that such anomalies could have been rectified. Such anomalies could have been rectified, as it did not adversely affected the purity of the selection process in any manner whatsoever. Notwithstanding such objection, a decision was taken with the approval of the CPMG, Chief Postmaster General, to cancel the entire process. The tribunal ultimately directed that the results pursuant to the process must be declared with all consequential action. We are tentatively of the view which decision of the tribunal is under challenge in the present petition. We are tentatively of the view. We have said tentatively. We are tentatively of the view. Mr. Chanda, don't get disheartened.
My lord, that may not be my lord. That may not be my lord.
Sure. We will say, Mr. Chakravarti, learned CGC, has submitted that with notification of more number of vacancies than what existed, the entire process got a jolt, which could not have been rectified. Apart from that, Mr. Chakravarti has further submitted. He has not submitted all this, but still we are. Because if we put our views, then perhaps if the other bench, if it goes, unfortunately or fortunately, then they will go by that view. Right. So we are leaving it open. And Mr. Chakravarti has further submitted that that with this direction by the tribunal, lot of anomalies would creep in the seniority position. Namely, the respondents, if found successful, against the advertised vacancy of the year 2019, would have to be placed senior to the persons who have become successful in 2020, 21, 22, and in others and in succeeding years. Lastly, it has been submitted by Mr. Chakravarti that after 6 years of the entire process having been kept in limbo, such a direction was not necessary. Such a direction was uncalled for. All that the tribunal ought to have directed was to re-advertise and allow the respondents to participate along with other eligible candidates, which the department is willing to do, but for the stay order operating before operating at that time before the stay by the tribunal, but for the stay order of the tribunal operating at that time. To this submission, Mr. Chanda has vehemently argued that for the fault of the department in notifying vacancies in excess of the existing requirement, the respondents ought not to be penalized, more so when their written test results were declared. He contends that though the respondents may not have the indefeasible right of being appointed or selected, but they definitely have a right to be considered, which right cannot be dealt with arbitrarily, as has been done in this case, especially in view of the objection by the ministry regarding cancellation of the entire examination process in its entirety. He further submits that with the direction that during the pendency of the proceedings before the tribunal and on the direction of the tribunal, a 3-member committee had been constituted to work out the vacancy available in the year 2019, even if it were after clubbing the vacancies of the preceding year against which no appointments/selections were made. Pursuant to the aforenoted direction, an exercise was carried out, and it was found out that at that time the actual vacancy was 75 and not 125. Mr. Chanda therefore suggested that the result would have been declared only corresponding to the number of vacancies, and in that case there was no necessity of scrapping the entire process, which entails time, resources, and the career prospects of the candidates. That apart, he has submitted that the defect which was pointed out was capable of being rectified without any difficulty, and that so far as the discrepancies in the holding of the examination was concerned, there is not an iota of complaint from any quarter whatsoever. Mr. Chanda, however, seeks some time to bring on record judgments indicating that merely because inadvertently the wrong vacancy position is notified in the advertisement, that is capable of being corrected, and on that score alone, the entire selection process ought not to be scrapped, leaving the applicants who have waited for all these years high and dry and losing out on the career prospects. This is all you will argue? We have dictated it, show us the judge. Re-notify 1 week later.
Now, my lord, the matter is of the record, I'm saying that one judgment of the APSC, Assam Public Service Commission, that was long way Supreme Court upheld it. It was reversed here, and then it was upheld by the Supreme Court. Favorable decision was given, and thereafter those SCS officers were appointed in Assam. I'll place anyway. I'll place.
Chanda, the litigation is running even today with respect to that examination. Are you aware of that? We are aware. We are deciding those matters today.
Obliged, Your Lordship.
We understand your predicament. We understand that. They have been absolutely reckless. But then after 5 or 6 years,
No, what about my lord? They are now like casual labor. Their status is like casual worker. Their status is casual worker. If they get this appointment, they will be permanent employee. That is the difference. They are like casual labor. Gamin Sabak means, my lord, like casual workers. They will get the regular appointment. Anyway, my lord, let it come after 2 weeks. I'll file it.
Next time you will not have to argue much. We will also not be required to argue.
My lord,
with
I got it. I got it.
On 9th March.
In fact, we should have written our tentative view, but for your request, we have not done that. All right. Yes.
Deeply obliged.
Item 32.
What is this?
My lord, the matter has finally been heard.
Huh?
In fact, my lord, this matter is otherwise in fracture. Finally heard on 19th.
Finally
I'm
heard,
happy to believe your statement. If it has become infructuous,
finally heard, my lord, reserved for judgment
where?
by the tribunal.
Reserved for judgment, no?
Yes, ma'am.
I will leave it. This way or that way, it has to be decided. So, the learned counsel for the petitioner as also the respondent Union of India are ad idem that with the tribunal having heard the matter before it and having reserved the judgment, this petition has become infructuous, dismissed as having become infructuous.
No, liberty, my lord, we can challenge it, my lord. The subsequent order that liberty may be given, my lord. In
I
case
think this
we are
is
agreed.
this is Mr. Gupta,
My lord.
you don't expect us to give you some primaries of law.
My lord.
It is only for that dismissal order makes it very clear that both of you are ad idem that because the matter has been heard and judgment has been reserved, this way or that way judgment will be pronounced, which will be challenged in an appropriate proceeding. This petition has become infructuous. What does it mean? Does it not mean that you will have a right to challenge it in case you're aggrieved? So why, sir, in High Court would you ask it before a Chief Justice's court? The Chief Justice who has come from outside would get an impression that these primary things, basic primer, you are not aware and you are advocate for the good organization. Huh? Mr. Das, Mr. Gupta, be careful before making any prayer. Not that we get angry at this, but we expect more, nothing we have done. It has become infructuous.